This is Senate Transportation Committee. It's Tuesday morning, February 20th. So we're going to go over some new testimony or updated testimony because we have updated the version of S-184, the automatic traffic law enforcement. So Judge Zoni is back with us again. Thanks for coming back and giving us your new thoughts on the new draft.
Sure. So Tom Zoni, Chief Superior Judge. I've had a chance to review draft 1.2 from February 15th. On page 6 of the draft, there have been changes where it talks about calibration laboratory. I just point out that I don't know what a calibration laboratory is. I don't know if I could start one and say I'm a calibration laboratory. In other words, if there's an organization that is recognized, or if there is a state agency that oversees calibration. I know there are scientific standards that oversee a number of, whether it's data masters and different types of scientific devices. So I don't know if there's one for calibration, weights and measures. I don't know, but I point that out only because that's a question that someone may have in the future.
So we hope we were addressing that with the language, but we still didn't quite get there.
It still doesn't tell us a calibration laboratory, but it doesn't say certified by or what.
And give us some research on that. There wasn't this, but there's another organization.
Yeah, there was another organization. So
I don't know of organizations for that, but I just know that there are different organizations for calibration to make sure that something is standardized. On line 18 of page 6, it talks about the first ticket that someone gets and the penalty. It says 0, which shall be exempt from surcharges under 13 VSA 7282.
Anything times 0 is 0.
Yeah. And then a written warning for the first violation. You wouldn't get a surcharge unless you have a violation found against you. And if you have a written warning, you would not have a violation found against you. So essentially, it's two separate thoughts. The one side of it is for your first ticket, do you get a written warning? Or for your first ticket, do you get a violation that's found with no penalty? The distinction between the two. And so that's a question for policy, how the legislature wants to handle that. But
that's line 18.
That's line 18 and 19. The judiciary just currently, we don't have a system for keeping track of written warnings. And generally, the officer would be writing down on the ticket what the penalty is, the waiver penalty. So someone, if they're going to plead to it, can pay it. So the officer would have to know this information up front about whether they had a prior violation or warning. But I think that it is, again, it's two sides of the issue. One would be you get a written warning and there's no judgment. The other is you get a judgment and it's exempt. So that's really a question for how you want to structure that.
But you're saying we would need the judgment if we want to track how many you get.
There may be other mechanisms. There could be created in law enforcement, could create a system whereby they keep track of such warnings. But then what you're doing is you are elevating a warning to a finding that someone actually did it. And that's not necessarily, if that's the intent, that we're going to give you a warning, whether or not the officer was wrong, or whether or not the statutes were filed or were followed, that warning now takes carrier free one. If that's the policy you want, that's a policy. Otherwise, what you really, it shouldn't be a written warning. It should be your first violation that is found, there's no penalty. Does that make sense?
Yeah.
Then on page 8, under lines 4 through 6, it talks about the sailors, military persons, soldiers, sailors Relief Act. Under the law, in order to have a default judgment, we have to have information about whether someone is or is not. Some statutes in some jurisdictions allow a default judgment to go forward as long as there's a bond posted to prevent any potential issues. one mechanism that you could consider here is to have the requirement of the affidavit under Title IV, Section 1105, have it be required still, so that when a ticket is issued, law enforcement has to send in, they check the box that says that they have made inquiry essentially, and there is a Department of Defense website that they can go to enable them to determine whether someone is in the military or not. And that's commonly done in civil violations. Someone can't get a default judgment on a small claims case seeking $50 unless they file an affidavit for default. Law enforcement can't get to, in this type of area for Judicial Bureau, they still need to file something because you can't act unless you know. And so I would suggest that the statute could say that in compliance with 4 VSA 1105F, the complaint shall include an affidavit that the issuing officer has ascertained the owner's military status to the best of his or her ability by conducting a search of the available Department of Defense Manpower Data Center online records, and a copy of the record obtained that is the basis for the issuing officer affidavit shall be included. Again, policy, do you want to put the burden on law enforcement for, I don't know how many tickets is anticipated, but to have them make sure that the men and women who are serving our country and maybe on active duty don't have to worry about this later, or minimize the risk that they have to. And again, this is consistent with most civil actions, that law enforcement has to take that step, or the plaintiff in a civil case has to take that step. And that would address the personal knowledge, because they're doing a search and they're telling the court what the basis of that information
And
is.
that database is available?
It is. It's used routinely. I'm sorry?
Publicly, or do you
Yes.
have to? Okay.
Publicly, it's my understanding, we see it every day used by attorneys and in many cases for default judgments.
Learn something new every day.
Yeah.
It's called it's DMDC, Department of Defense Manpower Data Center. On page 8, lines essentially 7 through 16. So the way this is set up is you're treating Vermont operators different from out of state. For a Vermont operator, the ticket has to be mailed within 30 days. And then there are procedures that go into place if someone doesn't respond in a timely fashion. For out of state operators, it's mailed within 30 days after discovering their identity, but it says that it shall be invalid unless provided to the owner within 90 days after the violation. So it has to be mailed within 30 days of finding out who the person is. But as I understand the statute, what you're saying is, but in any event, that 30 days has to be within 90. It has to be mailed within 90 days. Just to make it clear, you're not giving that same benefit to Vermont operators. In other words, if law enforcement does not within 90 days mail the ticket to the operators from out of state, what you're saying is it's done, it's over, right? Can't go forward. There is no such provision for Vermonters. So a Vermont operator could have it theoretically under this law 6 months later.
Equal protection.
I can't opine on constitutional. I'm just giving you the policy arguments there that you would have to consider, obviously, because I know that this would be a question that would be raised in court. Well, wait a minute. They didn't send it to me. I didn't know for 6 months. And as a judge, I'd look at it and say, well, the legislature clearly knew that it could do that because the statute for the out-of-state residents did that. So if you may want to consider addressing that. Also, the term invalid is not a term that is necessarily recognized. It can be voidable. Is it void? Is it voidable? And then it says unless provided. Or earlier on, you use the word mailed as your data point. Does provided mean actual receipt? Is there a difference between the word provided and the word mailed? And so what you could put in there is language such as, in the case of a violation involving a motor vehicle, registered under the laws of a jurisdiction other than this state, the notice of violation shall be mailed within 30 days after the discovery of the identity of the owner to the address of the owner as listed in the records of the official in the jurisdiction having charge of the registration of the motor vehicle. A notice of violation issued under this subsection may not be issued more than 90 days after the date of the violation.
Is that your phone or something?
It must be. I shut it off. I hit the little button down and silent. So that is something you may wish to consider adding some language in there that says the ticket may not be issued. Or you can go further and say a notice of violation issued more than 90 days after the date of the violation shall be void.
Judge, you have all this in writing, so I
Absolutely.
assume you could email to Ledge Council.
Yes.
Oh, well, why would you issue it if it's void by definition?
Under Rule 80.6, which is the rules for civil procedure, it does provide the hearing officer with the ability to void something. Sometimes law enforcement might make a mistake. And so if you make it clear that they can't, if it says they can't issue it, what if they do? And so if you say it's void if issued, then that tells the court when it comes in, it's void, and therefore that's defective and it can be taken care of on the court side.
Is there, excuse me, is there a difference between postmark and mailed? Is there, or just mailed is,
Work anymore.
Mailed is
Your postmark.
the date that you stick it in that nice blue box. I think unfortunately what we're learning now is postmarked is the date that it gets a stamp on it from somewhere else that might not even be Vermont anymore. And so, yes, I think there is a difference. We've always gone in our other civil rules and in other areas, we have gone with the date of mailing. That is the date that we have used. And that is consistent with whether it's the civil cases, judicial bureau, that's the date that we have used. So it is a standard date.
okay, thank you.
On page 9, line 4, it talks about where it says, to the extent not inconsistent with this subset, with this section, the provisions for adjudication of a Vermont civil violation complaint, the payment of a Vermont civil violation and the collection of civil penalties shall apply to civil. You're spelling out certain aspects of it. And I wonder why it just doesn't say, to the extent not inconsistent with this section, the provisions of Title IV VSA Chapter 29 and any rules adopted by the Vermont Supreme Court, procedural rules adopted by the Vermont Supreme Court shall apply to civil violation complaints issued under this section. Because that would tie in all the provisions of the sections, because Title IV, Chapter 29 is the area that references how you handle the hearings. And there's also a rule of procedure, Rule 80.6, that references how the hearings are held, and that is done underneath the Title IV provisions. And if you put in here that basically Title IV, Chapter 29, and the civil procedure rules apply, you've covered all your bases. And again, to the extent not inconsistent. So if there's anything that you have added here that is different, that would take precedence. It does allow, for instance, under the rules, the civil rules have in, Rule 80.6 has in within 21 days. It has the timelines. And so you build in the consistency that I mentioned last time so that we have one set of timelines for the proceedings in the environmental division, in the judicial bureau. Those would be about my only comments at this time. I'm not commenting on the rest of the bill, the procedures, and things.
Well, thank you for taking another look at it. We appreciate
Certainly.
your time.
Thank you for asking.
Very much.
So I did make some notes when you came in before, and you had raised the issue around multiple jurisdictions and the original as a concern where you might have multiple
The town and.
yeah. And then they obviously had the annual calibration to make sure something's accurate. owner who gets a ticket if they're multiple, both pay, question mark. Good cause and stolen plates. So I'm just wondering then, all the issues that you raised.
The owner was addressed.
Yeah, so.
And when I looked at it this time around, I did not have the number of concerns that I had before because it looked like Ledge Council had
Attempted
to address many of the concerns.
Okay. I just thought I would ask you, since those were the comments you made when you were in before.
Thank you.
And my copious notes.
Yeah, I'm impressed that you found. Yes, Senator.
Me too.
Distinction between violation and warning, you make a perfectly clarifying remark there. I took from it that makes more sense to offer a violation, a civil violation that's with the $0. You wouldn't make a case, and I know you want to wade into this category, but should it just be a warning? Should we pursue having it be a warning for $0? I get that we need to have clarity there, but do you have an opinion on it?
It's a policy decision, but I would note that the impact of the policy, if you have it tracking as a warning, you are you're basically taking someone's, I'll call it free pass, and saying, the fact that the officer said you did this is enough to use up that $0 penalty. We don't care if you have any defenses. We don't we're not going to adjudicate it. So if you're the wrong person, so whatever it may be, you're not going to have an opportunity to go to court.
You might get hit with an $80.
And so then your next time, which theoretically could be your first time, you're already starting at $80. And so that's the policy issue between a warning.
Quick follow-up, UVM issues parking tickets. The first one you get is a $0. I don't know if it's a warning or an actual violation. I'm gonna follow up with them. And then the second time you get caught parking in the wrong spot, you get an $80 ticket. So I'm
Yeah, so do some based on your salary.
Well, that's for the permit to park there. They don't do the fines based on, they charge you your parking rate based on a percentage of your salary to park in certain lots, but this is the fees. They give the first one as a waiver.
Maybe you should do the parking ticket based on your
There
salary.
you go. But I will send an email.
Okay. All right, thank you. Any
Thank you.
Oh, thank you.
My pleasure. Thank you. And if Ledge Council has any questions about the language, email me and I'll zip you the language. that I
Thank you
just
very
went
much, I
over.
will.
My pleasure. Thank you. Have a great day.
I guess I can throw my notes out now.
Mr. Schilling, you want to join us? Also a return customer.
Yep. So for the record, Falco Schilling, I'm the advocacy director with the ACLU of Vermont, and I appreciate you having me in today to talk about S-184 and the changes that were made. And I think I'll just start off at a high level, say I really appreciate the drafting that went into this. I think there was a lot of really thoughtful changes made based on some of the testimony we provided, some of the testimony provided by other witnesses. So in large part, I'm going to go through some of those changes that I think are positive, and there's one area of concern that I wanted to highlight. Above and beyond what the judge shared earlier, I think the judge had some good points, so I'm not going to spend too much time reiterating what he already discussed. So first, the limitation on page 4 that these systems would be used in work zones on interstate highways is something we discussed in terms of a way to alleviate some of the equity concerns where you have a very limited use of these on a public body, a public roadway, where I think you'll see the driving population is very representative of the driving population as a whole. So I think that alleviates some of the concerns that we raised theoretically about equity and where these could be placed. So I appreciate that change and that limiting language that was inserted in this newest draft. So just wanted to highlight that. I also wanted to highlight on page 8 and 9 that appreciate the changes made to the defenses section. I think this was helpful in terms of addressing some of the points of concern where you might not actually be the driver, or we have multi-car households, other things like that. So I think this defenses section is a positive change from our point of view, and really appreciate the change that was made in the draft around that. I think the judge raised a good point around the difference in process when it comes to in-state and out-of-state drivers, and I think that's something that's really worth looking at that could, making sure that those are addressed equally. I think maybe looking at the process for out-of-state drivers and extending those protections to in-state drivers as well would be beneficial. And then I also appreciate at the end of the bill, the sunset provisions and how that was done in terms of putting in place a prohibition on the use of this type of technology if it were to hit the point where we are allowed these to repeal. I know the intention probably would not be to allow repeal to go into a place. But one thing that we've seen sometimes be problematic when we have a sunset on some sort of new technology in an attempt to say, we're going to come back and look at this again, is that repeal would then leave that technology fully unregulated. And this goes the other direction, and I really appreciate that. And I think that was a strong change to the bill. So those are the things we found to be positive. My main concern just when looking at this bill is how it changes the penalty structure. And in particular, this is on page 6, in particular, the fact that we would be issuing tickets for any violation in excess of the speed limit. So I think before there was some language in there about,
11 miles.
Yeah, 10 or 11 miles, but I could see a lot of problems coming into play if we're issuing tickets for being 1 mile over the limit,
Sure.
where people would be more likely to challenge based on calibration issues. So maybe some sort of structure similar to what was included in the original bill, where you have I
That
guess.
was our intent. We
Yeah,
talked
I
about
don't remember
it.
talking
We
about
said
it.
it at 11.
Yeah, so I'm looking at some of that language and incorporating either a $0 violation or something along those lines for a lower level violation, I think would make sense, just because if it's 1 mile or 2 miles over, that's more likely to get contested and take up more resources. Though I think it's very appropriate if you are seeing any speed in excess that folks get a warning, but that we would be ticketing for $80 at like 1 or 2 miles over is also just pretty inconsistent with how we see enforcement happening on our roadways today. So all in all, those are the comments I had on the bill. I really appreciate the changes that were made. I think that this has been a thoughtful deliberation, and appreciate you taking our testimony.
Great. Yeah, I'm trying to think if it was in the definition that we said, like,
And if I missed that,
that is
I don't know,
11
we talked
hours.
about it though, with,
Do you have,
I think so. This
wanna
is
tell
Donna
us?
Russo Savage, Legislative Counsel. I actually have draft 2.1 that Anthony prepared on Friday.
so.
And on
Okay.
page 3, on 1.2, page 3, line 17,
5 miles?
it's changed to 11 miles, more than 11 miles above the speed limit. I don't know if that answers the question or
So I
not, but I
think,
know that
yes.
that change was made.
Right, I remember we talked about this. It's in that recorded image, like, there's only an image recorded if they're at least,
11 miles
Okay.
above.
right, this says 5, but I think we talked about
We
making
did
it.
talk about increasing it.
Well, I think that alleviates the concerns in terms of when that would kick in, but didn't catch that right off the bat in the penalty section.
It's
Okay.
further on, right.
Any questions for Mr. Sheldon?
Guess we're making progress.
We are catching up. Okay, thank you. Thanks for coming back in.
Thank you.
So Captain Pin from Ohio State Highway Patrol, I think, is with us. Hello, Captain.
Good morning. I have with me Staff Lieutenant Brad Longo here as well. So between the two of us, we do a lot with our license plate reader work here in the state of Ohio.
Great. Well, thank you. I don't know if you've looked at the bill. I didn't get to talk to you before you testified, but one of the things we were looking at is how law enforcement and states deal with this, since we haven't done it in Vermont for these kind of violations yet. So I don't know if you have testimony
Full
about
disclosure, we use license plate readers for completely different purposes than what you're proposing to do in Vermont. We do not use them for any sort of speed enforcement at all. The state does not. And there are agencies that do electronic speed enforcement in the state of Ohio, but the Ohio State Highway Patrol is not part of any type of, the only speeding tickets we write are the ones issued by our state troopers.
And that's by design. So like municipalities use it, is what you're saying.
Some of the municipalities do use some automated ones, but there are there are caveats in our revised code about how and when that is used. Like an officer has to be present to view it. It isn't just an automated process where they just generate it, or if they do, then they risk losing some funding.
Okay. So you use a license plate reader like what we did for a while. There was a couple of years where we did read them where you have them like on your squad car.
Correct. So we use them. We use both stationary and mobile license plate readers. Most of our mobile license plate readers are involved or are used by our commercial motor vehicle section. So what they do is they will scan, and they're using license plate readers, but they don't necessarily only scan license plates. They scan US DOT numbers on the sides of the commercial vehicles, and then if that will automatically run that DOT number through the federal database and return a safety score on that commercial vehicle company. And if their score is so low, then that is enough reasonable articulable suspicion to generate a traffic stop and do an inspection, a DOT inspection on that vehicle.
And our AOT for a while was doing that, but I think they even got rid of their license plate readers, I think. They were using them for a while, but yeah.
Or they're not saved. I can't remember.
The data.
Yeah.
Do you know how you save what kind of data?
So we save data for right now. Our policy is non-hits. So and this applies with both stationary and mobile license plate readers. Non-hits we save for 24 hours, and hits save for 31 days. So if it's an Amber Alert or if it's a stolen vehicle, those are considered hits. So those would fall into the ladder retention schedule. Non-hits, though, are only 24 hours. And we have a laundry list of success stories of using license plate readers where they've been able to help us locate either wanted fugitives or
We've lost them.
Looks like everyone's frozen.
Senator Mazza?
Yeah.
Amber Alerts look with children. It's been very. Sorry, I think I lost you there for a second.
Yeah, you're back.
Yeah.
Yeah, I think you're back though.
Okay, sorry about that.
No, we got the gist of it. They can be very successful when you're looking for a specific vehicle.
Definitely.
We've been looking at the safety issue in work zones, particularly because of the risk and the safety issues. Do you have something comparable, even though you're not using this technology, or are you just having officers at those work sites?
So we partner with the Ohio Department of Transportation, and they identify their high risk work zones every year, and then they offer overtime, funding that we can pay our officers overtime, because if they're on overtime, then they're in a dedicated status where that's all they're focused. They're not out handling crashes. They're not taking calls of any sort. They are out there strictly for enforcement purposes. But again, it's good old fashioned laser radar, and they're witnessing the violation, pulling the vehicle over, issuing a traffic citation.
That might be something else we could do, because right now we have law enforcement at the work zones, but they're there as a warning. They don't actually pull anybody over. They're just there with their lights on, so people see the vehicle and then hopefully slow down. But they're not.
There are times where our officers are used in that capacity in work zones as well, but a lot of times what we're doing is we're essentially, our troopers and sergeants are unionized, so there is a process for posting overtime per their contract. But we post overtime for specific geographical areas, and then they can sign up for that voluntary overtime on their day off or butting their shift or whatever, and then they're out there doing an enforcement detail in those high risk zones.
Right. Okay.
Thank you.
Any other questions for our friends in Ohio?
No, thank you very much. Very helpful.
Yeah, unless you have anything else, yeah, so I think we thought you were using it for speed enforcement, so but you should be taking the time out of your day.
I apologize. Have a good day.
That's all right.
Thank you.
Thank you.
It raises the question about what the value is for a sheriff stationary who can't do anything. You just put
Yeah.
a blue light or,
Right.
a car, with a blue light on it.
Well, hopefully
And then-
people slow down.
And then have the sheriff do the enforcement at the other end.
You kind of need two.
No, you don't need two. All you need is the blue light. The sheriff isn't doing anything. Even if they speed, they can't leave.
Right.
Right.
So why not just have some kind of a blue light on an empty car and have the sheriff down at the other end to enforce the speed limit? I mean,
Yeah, no,
am
it's,
I missing something?
no, we've
No, you're not.
discussed that
That's
before.
where I have been. That's where my thought has been, for sure.
I mean,
And
that's
maybe-
the whole point, isn't
I
it?
just think it's
Yeah.
crazy that you're just sitting there and you're just sitting there all day long, and the expense of paying somebody to sit there all day long just to run a blue light
Yeah,
just doesn't make sense to me. That money could be spent better elsewhere.
Well, I think that's partly why we're looking at this, because this is just a better way to spend the money and get better results. So with that, the next person we have on our list is Dr. Farmer for the Insurance Institute for Highway Safety. Well, we were told that the Insurance Institute for Highway Safety has done some work on this. I think there's some documentation you've published. So that's why we asked you to come on and tell us what you know or think about automatic traffic law enforcement.
Okay, as you said, I'm Chuck Farmer. I'm Vice President of Research here at the Insurance Institute for Highway Safety. And I thank you for having me. I guess my purpose is to talk about the research and to show that automated enforcement does what it's supposed to do. Basically changing driver behavior. Drivers obey the laws when they think they're going to get caught. And so we've got police out there, but police try to be as visible as possible in order to have that deterrent effect, because they can't catch everybody. Automated enforcement just adds to that. It's a supplement to the traditional enforcement that we've got going on. And the more common uses for automated enforcement are speeding and red light running, which are part of your bill. There are other things. Some people use it to stop people who are blocking the box or just various sorts of, I've seen them used at stop signs as well. But we'll just talk about speeding and red light running. Speeding is a major factor in motor vehicle crashes, especially the more serious ones. In 2021, which is the latest data we have for the nationwide, speeding was a factor in 29% of motor vehicle crash deaths, which comes out to about actually more than 12,000 people who died in speeding related crashes that year. In Vermont, I looked up the Vermont numbers. Numbers are smaller there, but the percentage is actually higher. 41% of the deaths in Vermont in 2021 were speeding related. So it's a problem, and it's a problem everywhere. It's not just Vermont, it's every state. I'm in Virginia, it's a problem here. Speed in general just affects both the crash likelihood and severity of the crash. It lessens the time that you have to react to an emergency. It increases the stopping distance, so it makes it less likely that you're going to be able to stop in time. And then when you do hit something, I think we all know this, we don't need to be studying physics. You know that faster you're going, the more it's going to hurt should you run into something or somebody. So you're going to have a more severe crash with higher speed. And for that reason, we want to enforce the speed limits that you lawmakers have put out there. And I was talking about inside the crash, it's more severe, but those people that are outside your vehicle, the vulnerable road users like pedestrians and bicyclists are especially affected by speed. Research says that at 20 miles an hour, a pedestrian has a 5% chance of being killed. When you get up to 30 miles an hour, it's more of a 40% chance. And when you get up to 40 miles an hour, it's more like an 80% chance. So you don't have to increase speed by much. Most of us don't think of as 40 miles an hour as being really fast. It doesn't have to be that fast in order for it to affect those vulnerable outside the vehicle road users.
Senator Chinden has a question.
Sir, you're validating my perspective on this. My one question, I'm not familiar with your research. I'm sorry, I didn't know you were testifying today, but I will look into it afterwards. Does any of your research touch upon the an effect on the fee structure, like what amount it is, whether or not there's a warning? Is there an optimal thing to consider as we're looking at how much these fees, or picking the right word, violations or assessments or so on? Any advice on the structures and to impact safety optimally?
The research that's been done on fees has really not found much of an effect unless it's really large fee. So it's a difference between a $20 fee and a $40 fee. I don't think there's any difference in driver behavior when you've got that going on. When you get up to $200, I think that's where you start to see more of a deterrent effect. So it's not so much the fees, it's just the likelihood of being caught that's more important in terms of deterring drivers from breaking any kind of rule.
The evidence here on the benefit is based on the information that we have before us is pretty compelling as it relates to the impact it has in terms of the reduction by, you have 70, 88, and 82% respectively after cameras were introduced. So it does seem like they have our goal is not to raise a lot of money, it's to protect the workers and see if this technology can help. So it does seem like, at least from the paper that you submitted to us, is that this is an effective way of addressing speed in work zones. And work zone speeds here on the interstate are 55 miles an hour. So when you're talking about if you hit a driver, even at the posted, you're dead, I guess, pretty much.
If you hit a flagger.
If you hit a flagger, right?
Yeah, the research is just, there's no doubt about it. I've been doing this for 30 years. And so if you look at the references, my name's in there a lot because I've been looking at this particular type of research for those 30 years. I think it was 1994 we did our first study on red light cameras and found that, yeah, if you put out automated enforcement, behavior just changes immediately. Red light cameras, I think we saw a 40% reduction in running red lights. Speeding cameras was even greater. We saw 80% reduction in speeding when we put in cameras immediately.
Yeah, that's what we've heard from others too. So this is good to see that your research bears that out.
Right, and there's crashes as well. I mean, that's the next question is, if you change behavior, do you also reduce the number of crashes, and especially these severe injury crashes, which are common when you have speeding, and they're common when you have red light running, because you got those T-bone crashes where you're running into often the driver right there on the side impact. So yeah, we and I won't go through the numbers again, but we see huge reductions in those serious crashes after we put in either red light cameras or speeding cameras. And I think our latest study looked at what happened when cities took away those cameras. And you saw increases in the serious crashes in the cities that took away the cameras.
Senator Chittenden.
From what you know about what we're considering here in Vermont for work safety zones, are there any states, since your vantage point seems to be looking at all 50 of them, that you might encourage us to just take a gander at what their legislation worked through, or any experts out there in the field that you would want us to hear from as we dip our big toe in this arena?
Where we've seen the biggest effect of a long-term program was in Maryland. Montgomery County, which is one of the suburbs of Washington, D.C. They put in their speed camera program, I don't know, at least 10 years ago. And we did a study with them and saw an immediate reduction in bad behavior and an immediate reduction in serious crashes. We followed that, since our office is right across the river from them. We followed that for like 8 years, and after 8 years, there was still this reduction in both bad behavior and crashes. And one other thing that comes out of this that I haven't talked about yet is public opinion. The people in Montgomery County were very much in favor of this program, even though when we asked them, have you ever gotten a ticket, or did somebody in your family get a ticket? Most of them said yes. A lot of them had had the experience of getting the ticket, but they still support the program.
Yeah, I saw that in your paper. I was also glad that you gave a shout out for roundabouts.
Yeah, I mean, automated enforcement is not the only solution to these
Yeah, you
problems.
don't get T-boned in a roundabout.
Yeah, and you
Right,
have to
right, yeah.
take that turn. Yeah.
If you
Assuming
want to
you
cut
feel
down on
that-
crashes and intersections, just redesign the intersection.
Yeah.
Same thing with speeding. If you want to cut down on speeding, sometimes you can just redesign the roadways.
Speed bumps.
Yeah, speed bumps, but you can't always do those things. So, automated enforcement just goes in the toolbox.
Does every state use a different color lights for enforcement, red or the blue or caution, or they are all pretty much uniform?
I don't know. I've only seen blue when I've been driving around. So I
Okay,
don't know if there are states that do it differently.
okay. Curious. Thank you.
Hope not, we just passed.
And the Institute does have a checklist, which they also submitted, that I haven't looked at too closely, but my understanding is that the Institute did that for other municipalities or states that are looking at automated traffic enforcement.
Right, because you may have read stories where automated enforcement was canceled because the public outcry was just too great. And so it can be done wrong. And we put out that checklist to help people avoid that, especially the part where you make it as part of your budget and you actually play up the fact that you're making all this money off it. You don't want to make money off it.
Yeah.
Your goal is you don't want anybody violating. So you don't want to make any money at all. You don't want to have any violations at all. That's your goal.
Yeah, no, I've seen that where other places it's, at least the criticism has been that it's just a way to bring in more money.
Mhm. Yeah, it's the optics. It can look bad the way you present it. And so our checklist goes through all this stuff of, first of all, make sure there's a problem and publicize what the problem is so the public knows why you're doing this. Show that you've tried other things and you haven't solved the problem with those other solutions. So you're going to try this, and then try to keep that public support. Make sure you get a lot of attention. Make sure the media is covering what you're doing, and hold on to that support. Involve the community in your committees for monitoring the program, and show that it's working. I mean, that's the last step. Is
Right.
Once you've got this thing going, bring out your crash data, bring out your enforcement data, and show the public that this is actually doing what we set out to do.
Yeah, no, I think this checklist will be helpful.
So now we have Mr.
Is
Miller.
any, yeah, we can go to Mr. Miller, who's been very patiently waiting. Unless you have any other questions for Dr. Farmer?
Thank you.
Thank you, very helpful.
Yeah, I appreciate you doing that. Mr. Miller, thanks for joining us at the beginning and waiting this time. So you can tell us what Vera does, and I think you sent in a presentation as well.
Right here.
Yeah, and I'm happy to share that on the screen. First of all, thanks for having me today. Lou Miller from, I know it says Lewis, but we can go with Lou, that's fine, from Vera Mobility, Senior Vice President of Global Operations for Vera. We currently support the work zone program, statewide work zone programs in Pennsylvania and New York, and have supported Connecticut in their recently concluded pilot in the state as well. So happy to share some thoughts on those experiences, and can share the presentation on the screen to walk through it, or if you have it there, either way.
Yeah, if you share it on your screen, then if anybody in the public is watching, they would be able to see it. Megan, does he have sharing capabilities?
Yeah.
Sure. I think, let me see if I can, let me know if that's coming through, okay.
Yeah, we can see it.
Okay, yeah, I also wanted to note that having listened to the testimony today, I can share a couple thoughts at the beginning on some of the topics that were raised, just factual information. If that would be helpful to the committee, I can run through those quickly.
Yeah, go ahead.
Yeah, I think the first topic was around the independent lab. There are independent labs in several states. Vera Mobility uses one in Pennsylvania for the work zone programs, in Connecticut, New York, and Pennsylvania to do an independent annual calibration of the equipment used in the program. So I know there was discussion around independent labs and certifying the equipment, and those do exist. And we use one in Pennsylvania, or have for all three of those programs. Kind of secondly, there was some discussion around warnings versus a $0 NOV. We'll touch on it in a minute, but our platform that we use, and that is typically provided with these programs, has the ability to track that tiering or warnings, define carrying notices. So we could touch on that in a little bit more detail if it would be helpful. In terms of the discussion around the speed threshold, yes, it is typical, or we've seen where legislation does clearly identify the speed threshold that would apply for a violation, which is most typically in that 10 to 15 mile an hour range. But that clarity is helpful. And then in terms of the discussion around fees from the IIHS, we typically do see fees ranging from a low of in the range of $40 per violation to several $100s. Typically, that's tied to whether these are treated as administrative or criminal violations. The programs that existed in New York and Pennsylvania, that they're hybrid administrative penalties, so fairly typical to what you're considering here, in the $75 to $150 range. If I recall correctly, I think your bill is maybe 80 and then 160 in terms of the tiering, but that's fairly typical for legislation that we see. So just a couple thoughts on those comments. I would be happy to get into in more detail if that would be helpful.
Sure, we're not seeing the slide advance on what we're seeing, so.
Yeah, he's going through his comments on our earlier testimony first.
Oh yeah, let me see if I can you see that now?
Yeah.
I advanced it.
Yes.
Okay, let me minimize here. So you should see a slide now that says safety program highlights.
Yeah.
Okay, so won't spend a lot of time on the slides, but I think the takeaway here is typically when a state contracts for these types of programs, it involves not only the provision of the technology and the deployment roadside, but also a back office platform that's used to process and manage the data as well. And that's really what I was touching on in terms of the ability to track warnings, the number of violations or incidents, per plate or registered owner. So I think it's important to know that often, it doesn't have to, but in most instances, and that was the case in New York and Pennsylvania and Connecticut as well, is it involves not only the provision and deployment of the equipment roadside, but that software package that comes with it as well.
Right.
And just moving on, you'll hear the term often of turnkey services, right? So, typically what that involves, again, just going into a little bit greater level of detail, and would be, the provision of the equipment, the deployment, the annual calibration to ensure proper operation, maintenance, training, print and mail services for notices, hearing and court support. So these types of wraparound services are typical in programs that state agencies contract for work zone programs.
Mr. Miller, Senator has a question.
Thank you, Mr. Miller.
Yeah.
Glad to have you here. As far as just going back just one little bit.
Yeah.
As far as the tracking and all that, no matter what the state wishes for you to do, which I know that's what you'd want to do, what is your company's policy as far as the information that you gather? Do you take that information and use it further along the way, or as far as public information? Or what do you guys do with the information, even contrary to the wishes of what the state would want?
Yeah, the information is used solely for you would lay out what your data retention and use policies are that would apply for the program, and we would follow those policies. Typically, the information would be, not typically, it is used solely for the purpose of the program. And usually in the agreements that we have with providers of registered owner information, whether that be NLETs or directly with the state agency, they would have very, very clear restrictions on use of that data as well. So you don't see what I would call cross-pollination of data or use for other programs or interests.
Not to make it sound accusatory or anything like that.
No, that's fine. Yeah, it's a good question.
As far as that data that isn't used or sold anywhere else, as far as to further some other industry or anything like that.
Correct, 100%.
Okay, thank you.
That would be agreement.
Right. But you're still, yeah.
Yeah, to put that in perspective, a vendor would risk losing access to that information from providers, state DOTs, DMVs, and law enforcement if the restrictions on use weren't complied with through periodic audits and other things that occur.
Thank
Imagine insurance companies would like that information, wouldn't they?
Well, exactly.
Yeah. Frequently, what we see in state legislation is it prohibits. That would be obviously determined by the state, right, or the agencies. But it is not uncommon for legislation to specifically prohibit the sharing of information with insurance agencies if that's a route that Vermont chooses to go.
That would be part of it. Okay.
Well, that does pose some real interesting things, because your second offense, if you got picked up by the state police, I think that becomes part of your record and it's available to the insurance agents. If you use this method and you do it a second time, it does not. So.
Right. Important to know.
Yeah. Okay, you can continue with your presentation.
Sure, thank you. So just a little bit more information on how deployments work. Typically in these programs, the state agency administering the program would provide a schedule to the vendor that specifies the work zones the date and time to deploy the equipment. So the decision as to where to deploy the equipment comes from the agency, not the vendor. As noted earlier, the vehicles that we deploy as part of the program all have the enforcement systems contained within or on the unit, right? And in addition to the annual certification from an independent lab, there are daily system checks as well that are noted in logs to confirm proper operation or accuracy of the system. And then the incidents that are captured, and by that I mean someone who is traveling above or driving at a speed above the designated threshold. There's images, optional video, and data that's captured with that is then securely transmitted to the back office platform. That's typically done wirelessly through a secure and encrypted through a secure VPN. So security end to end around the data from the roadside into the back office platform.
Okay.
See if I can advance the slide deck here. Just a little information around that platform that would typically come with one of these programs. Again, it ingests the data from the roadside. Typically, that data is pre-processed, but an important point there is that's done in accordance with rules established by the administrating agency. So an example of that in real world terms is, what do you do if an incident is captured and there's no plate on the vehicle? What do you do with that would be an example. Typically, a vendor would acquire the registered owner information, and then that information along with the data and images would be queued up in a secure web-based portal for law enforcement to review. So a standard requirement for these programs is, although a vendor may do some pre-processing of the data in accordance with agency rules, law enforcement makes the final decision as to whether a warning or a citation or notice is issued. And then there are a variety of case management tools available in those platforms, which include customer service, payment processing, support for hearings in court in terms of provision of evidence, reporting and public awareness. It's fairly standard in these programs that if a warning or a fine carrying notice goes out to the public, that it would include a PIN which would allow access to the public to review the information that's captured.
Okay.
Just an example, case study from Pennsylvania. Won't read the slide except for to say Pennsylvania's program started in early 2020, right before COVID, and has been running consecutively since then. And I think consistent with the testimony you heard from IIHS, has shown some significant positive impacts, both in terms of speed reduction and work zone crashes. There is a footnote there at the bottom of the slide for the publicly available report on the program if you haven't had access to that or would like to review it in more detail.
Yeah, that's helpful.
Yeah. Probably of significant interest could if the committee would like to discuss it, are kind of vendor observations of lessons learned, supporting programs in multiple states now. Just running through those quickly, or would be happy to take any specific questions. One thing we've seen in the programs is having clarity around the process for contesting violations is very important in terms of the setup and administration of the program. We've seen administrative type hearing processes with appeals into the state court system. I would say that's been very successful. That's used in Pennsylvania. We've also seen coordination through local courts, which depends on the location in which the incident or violation occurs, which can be challenging from an administrative standpoint. That's a long topic, but I do think it's something it's good to understand up front in these programs. One thing, kind of building on a comment earlier, in a tiered structure like being considered here, I believe, and this exists in Pennsylvania as well, that whether it's a $0 violation or a warning, and don't have an opinion on that as a vendor, because it is the first violation is a condition precedent to subsequent violations. Pennsylvania does include the right to contest those warnings, so something to keep in mind. Another issue is around grace periods. With automated enforcement, there is a lag between the time the violation is captured in the field, right, and when it is ultimately approved by law enforcement and sent to the registered owner. So some states have considered grace periods such that if multiple violations are incurred in short order, that someone perchance doesn't receive a warning, a first violation, a second violation with fines over the course of just a couple days without having actually received the warning or $0 notice in the mail. And so Connecticut used that as a mechanism, and Pennsylvania's recently introduced it as well.
Okay, we have a question.
How many states are you in, sir? Three states?
I'm sorry, could you say that one more time, please?
How many states are you in?
We support the active programs in New York and Pennsylvania today. We also support Connecticut, which just completed in December their 1-year pilot program, and are compiling their final report right now. So 2 active, plus just recently concluded in Connecticut their pilot program.
Thank you.
Yeah.
It's only 10 states nationwide are using speed cameras. Okay. Yeah. Thank
Yes.
you.
Yeah. Clarity around signage requirements, which are included in your legislation, is important. I think some of this can be handled through rules and SOPs. But for example, how to deal with situations like on ramps, off ramps, et cetera. It's important in these programs to have clarity around signage to make sure that motorists are receiving the notice that's envisioned in these programs. Clarity again around worker presence or activity in the work zone and how that's defined is important. There was some discussion earlier on transfers of liability and how that would work. That's important. And then the discussion around vendor fee structure. In the programs that we're involved with, and I think this was touched on briefly by the gentleman from IIHS, none of the vendor fees are tied to revenue generation for the program. You know, the fees are tied to the delivery of the service as opposed to revenue generation, which I think you know, again, that's for the state to decide, but there are public perception implications in terms of fee structure as well. So happy to answer any questions on that or anything else along the way, but wanted to quickly share some of the experiences that we've had and a general overview of how these programs work.
No, that's helpful. The links and the other programs and some of the stuff like the grace period we haven't talked about, so that's helpful. Any questions? Mr. Miller here. And now we know how to contact you if we have other questions. Senator
Well, there
Kitchell?
was another person on the screen, but just left.
Yeah,
I didn't see him on the agenda.
they were also with Craig, which is Mr. Same.
I see.
Okay, well, thanks for your time and
Very much. Thank you. Helpful.
Yeah, appreciate the opportunity. Thank you. Have a good day.
You as well.
Yes, Senator.
5 minute break, I'm sorry.
Yeah, it would be good. Is that okay with you guys that are here, Kirby? And yeah. Okay, we will take a 5-minute break.
Also, I made a quarter, 12.